So we're going to go ahead and get started with our last session panel called The Last Word on Fraud, Everything You Need to Know About Negotiating Fraud-Related Provisions in Acquisitions. And we're joined here by three panelists, Richard Climan, who's a partner in the M&A group at Hogan Lovells, Keith Flaum, who's a partner in the M&A group also at Hogan Lovells, and Jessica Pearlman, who's a partner in the corporate practice at K&L Gates. So I'll turn it over to you.
Thank you very much. Welcome back, everyone, from our terrific whiskey sipping event and to our last presentation of the day. My name is Rick Climan, and I'm a deal lawyer based in the Silicon Valley office of Hogan Lovells. I'm joined on the dais by my longtime colleague, also from Hogan Lovells Silicon Valley office, Keith Flaum, who rejoins us here at UT after a lengthy hiatus. Those of you who've attended the UT M&A Institute from the very beginning will remember Keith from the early days of the Institute when the two of us, then at Cooley, regularly duked it out in mock negotiations on various public company M&A related topics. Remember, this institute actually began as a more public company focused institute. And more recently, you'll remember seeing Keith featured in some of the animated M&A negotiating cartoons that I've shown at this conference from time to time. So welcome back to the Institute, Keith. We're joined on the panel today by Jessica Pearlman, M&A partner extraordinaire, who practices in the Seattle office of K&L Gates and has many credentials associated with the M&A committee. Jessica will be our neutral commentator and fountain of information today. Our topic today is fraud. Everything M&A lawyers need to know about negotiating fraud-related provisions in acquisitions of privately held businesses. We've chosen this topic because in our experience, there are far too many deal lawyers out there who are probably not as well informed as they should be on this important subject and who may not really know how to negotiate these often nuanced provisions. As advertised, our format today will be our tried and true mock negotiation format, with which most of you, I believe, are familiar. Keith will play the role of outside counsel for the buyer. I will play the role of outside counsel for the seller, who we assume is the sole shareholder of a target company being sold. And Jessica will play the role of neutral observer, commentator, and probably occasional peacemaker. Our mock negotiation exercise will be built around this very simple hypothetical that you see on the screen. Keith's client, the buyer, is a publicly traded corporation which is looking to buy the target company from my client, the seller, by means of a simple purchase of stock. The key economic terms have already been negotiated. The purchase price, which the buyer will be paying to my client, the seller, for 100% of the target company's outstanding shares, is $300 million. There will be a general indemnification provision under which the seller will agree to indemnify and pay the buyer after the closing for any losses suffered by the buyer as a result of any of the seller's general representations about the target company and its business being wrong, having been false at the closing. Now, this general indemnity will expire 12 months after the closing, of course, except as to any indemnification claims submitted before the deadline. And note, we will keep calling this provision a general indemnity, primarily for the purpose of distinguishing it from any special indemnities that may be separately negotiated by the parties, including any special indemnities that may be negotiated around the topic of fraud. More on that a little later. And then finally, the buyer will hold back 10% of the purchase price in an escrow for 12 months following the closing to secure its rights under the general indemnification provision. So now, Keith, let me begin by asking you, why did you insist on this general indemnification provision when I instead offered you a perfectly good rep and warranty insurance policy, a policy made available through one of the many talented RWI brokers that are sitting in the audience today? And that was an RWI policy which my client, the seller, would pay for in lieu of the general indemnity. So we could have had, if you'd been a little more tolerant of that idea, a simple no indemnity deal. But you just thrive on complexity, obviously, because you want to make things complicated with complicated general indemnification provision.
Actually, Rick, it wasn't the complexity. My client is a strategic buyer, and it didn't want to use rep and warranty insurance because that's a very imperfect substitute for indemnification for the reasons you well understand. A no indemnity deal that exclusively relies on representations and warranty insurance has some problems. First, it takes away my client's sandbagging rights, which, by the way, I like to call the benefit of the bargain rights, which allows my client to recover even if it knew about a breach of a rep and warranty. It still can recover. And it also allows my client to recover for breaches of covenants, which a rep and warranty policy doesn't. The RWI policy exposes my client to the so-called interim breach risk, especially where there's a long time between signing and closing. And an RWI policy excludes coverage for a number of really important reps and warranties. So we just don't like that.
Look, I understand that position, Keith, and as reasonable negotiators, my client and I have accepted your position. There will be general indemnification, but we did make our acceptance of that general indemnity contingent on getting the limited one-year survival that I mentioned and the 10% cap on my client's potential liability under the general indemnity. These are limitations which you accepted and agreed to as part of the package. So I assume you agree that since reps and warranties and the associated indemnification remedies are all about risk allocation, we've come up with a reasonable allocation of risks in our negotiations thus far. Would you agree?
I do agree. Ultimately, reps, warranties, and indemnities are all about risk allocation, and I agree. We've come up with a fair compromise here.
Okay. I feel the same way. Hold that thought. But before we start negotiating the fraud-related provisions, I'm going to make an appeal to you, Keith, in an attempt to head off the hours of tedious negotiations on fraud-related provisions that we would otherwise be facing. An appeal to be reasonable and, above all, practical. I'm going to be suggesting some reasonable limitations on your client's fraud remedies, and I would ask you, I would plead with you not to take an academic ivory tower approach to these negotiations. Do not be a lawyer's lawyer. Don't be a purist. This is a big-ticket M&A deal we're negotiating here between sophisticated parties. This is not some two-bit penny stock securities Ponzi scheme involving shell companies. So please, I urge you to please be practical. And as a practical matter, you know my client won't commit fraud in a deal like this. You know fraud is vanishingly rare in big-dollar M&A deals between reputable and sophisticated parties. So why should we waste hours and hours of our time negotiating about something that's never going to happen?
Well, Rick, that's an interesting view. It sounds like you're worried about something. But before I get into that, let me ask Jessica to answer the question, because she's read all the cases and knows them cold. So Jessica, what about that?
Well, actually, fraud's more common than you might think in large M&A deals. There are two recent Delaware M&A cases noted here on this slide. Both of these cases resulted in 8-figure fraud judgments for the buyer, and this is just in the past year alone. And of course, these are just a couple of examples of actual findings of fraud. If there was an allegation that was settled, that's probably much more common.
And Jessica and Rick, I might not read all the cases, but I do read the newspaper, at least when I'm not watching my 11-year-old on TikTok, which we can discuss at a different time. In the last couple of years alone, I followed 2 major criminal trials relating to fraud in large M&A deals. The first one is the HP Autonomy deal. In 2011, HP paid $11.1 billion for Autonomy. Shortly after the deal was closed, HP conducted an internal investigation that revealed significant accounting irregularities at Autonomy. And it was found that Autonomy, in fact, inflated its revenue by misclassifying hardware sales as software licensing deals.
But wait a second. I thought the defendant in that case, in that criminal fraud case, was acquitted.
So while HP sued the CEO, Mike Lynch, and the CFO for fraud, the former CEO was acquitted of criminal fraud, but found liable for civil fraud. But let's talk about the next case, which is super recent. JP Morgan bought a company called Frank, whose founder was a woman named Charlie Javis. It so happened that JP Morgan paid $175 million for Frank, which was a student financial aid application assistance company, and the founder and her colleague made up a customer list. They said that they had 4 million customers when in fact they only had 100,000, committed clear fraud. That deal closed. Javis and Amar, her colleague, were charged in 2023 with criminal fraud. Just in March of this year, they were both found guilty of criminal fraud on all counts. And a few days ago, Javis was sentenced to 7 years in prison, to forfeit $22 million of profit, and she's co-liable with her co-defendant for $287 million in restitution. So, you say it's not common. Well, there are some recent cases that shows that it definitely happens. And in a criminal trial, Rick, it's even harder to prove. You got to prove beyond a reasonable doubt, and still she was held guilty. So the assertion that fraud is almost never happens in sizable M&A deals is just a complete myth. The fraud provisions we're about to negotiate are among the most important in the deal. And so while, of course, I'm going to be reasonable and practical as I always am, let's just say I'm going to negotiate the hell out of the fraud provisions.
Okay, then let's get into it. Jessica, as a starting point to set the stage, what are we talking about legally when we talk about fraud? What are the legal elements of a civil fraud claim in the state of Delaware?
Well, it's both pretty simple and yet not at all easy. So let me explain. There are slight variations from state to state, but generally under Delaware law, a seller of a business commits the civil tort of fraud if the seller makes a materially false representation, whether orally or in writing, to the buyer, and makes that false rep with scienter, either the intent to deceive, so knowledge that the rep is false, or with reckless disregard for the truth, and the buyer reasonably relies on that false rep and suffers damages as a result. So for a buyer to prove the seller committed fraud, there's a lot of hurdles to overcome. The buyer has to prove that a rep made by the seller was wrong. The buyer has to prove the materiality of the misrepresentation. The buyer has to prove scienter on the part of seller. Again, that's the illicit state of mind or that recklessness. And the buyer has to prove its own reasonable reliance. With all those hurdles, fraud is pretty tough for a buyer to prove. But if the buyer can successfully prove fraud, which is a tort, it's going to unlock and gain access to some pretty tough remedies it wouldn't otherwise have access to, including uncapped damages, punitive damages, and possibly even rescission.
So, Rick, in that context, I hope you're going to agree that the fraud-related provisions I've included in my draft acquisition agreement are reasonable and customary. I've included 3 basic provisions. 1, a provision that expressly preserves my client's common law fraud remedies for fraudulent representations, both inside and outside the acquisition agreement, a customary definition of fraud, and a customary fraud indemnity that will supplement the general indemnity we've already agreed to. So as you look at it, I doubt you're going to have any problems with them.
Well, I'm sure I will have problems, lots of problems, but first, I'd like to take a step back and talk about things on a conceptual level, channeling my inner Glenn West here. Keith, we have spent the better part of a week painstakingly negotiating countless pages of dense seller representations and warranties, along with a comprehensive general indemnification provision. We've ended up with 29 very broad reps and warranties and an indemnification provision with customary limitations, as we discussed. And as you know, these reps and warranties and indemnification provisions and the negotiated limitations applicable to them, the cap and the holdback, et cetera, are basically risk allocation provisions. And after a week of tedious back and forth, we arrived at what I would consider a mutually acceptable allocation of risks between the parties. We've already discussed this, but don't you agree?
I agree with what you said, and I agree we already discussed it, so I agree we should move on.
Okay. So given all that, what I'm inclined to do, Keith, is to delete, to cross out all of your proposed fraud-related provisions on this slide, and I want to replace them with one single disclaimer. A disclaimer that the buyer has no separate remedies for fraud, no special remedies for fraudulent misrepresentations by the buyer, as distinct from non-fraudulent misrepresentations. And I'll tell you why I'm doing this. It's because the buyer already has this powerful general indemnification remedy that we've negotiated, subject to the risk allocation provisions that we've negotiated, for all 100% of the inaccurate representations made by the seller, whether they be fraudulent misrepresentations or not. I propose that fraudulent misrepresentations be treated no differently than innocent misrepresentations. As a practical matter, the economic harm to the buyer is no different in either case. It shouldn't matter whether or not the seller knew the representation in question was false or was merely negligent or purely innocent even. As a pure economic matter, the seller's state of mind is irrelevant. The risk allocation should be the same either way, so that's my position. No special remedy for fraud. Your client's powerful general indemnification remedy is sufficient and is consistent with the agreed allocation of risks. Case closed. Does that make sense to you?
No, Rick, that makes no sense at all. If your client commits fraud, all bets are off. And the limitations we negotiated on indemnification, including the 10% cap, just shouldn't apply. If we can prove that your client made a false representation in the agreement with nefarious intent, we want unlimited fraud remedies.
Well, I hear what you want, and I hear your words. They're just conclusory statements. Why should it matter whether the breach of the rep was innocent or deliberate? Just because of some vague moralistic feeling you have that lying is bad and needs to be punished?
Well, Rick, I guess you're more tolerant of dishonesty than I am?
I'm just saying that in this case, alleged dishonesty on the part of my client should not matter economically. And why do you think it should?
Rick, I can answer that in 3 words. Fraus omnia corrumpit.
Keith, I can barely understand you when you speak English. What the hell language was that?
Yeah, I figured you might not know. That's Latin. It's a Latin maxim, and it means fraud vitiates everything. It vitiates everything it touches. Fraud trumps everything, including the artificial limits on indemnification.
Well, I'm impressed, Keith. I never really thought of you as a Latin scholar, but I must admit you do sound very scholarly when you speak Latin. But those are just conclusory words, and I'm going to respond in kind with another Latin maxim, and it too is only 3 words. Flocci non facio. Would you like a rough translation?
Well, I would. My Latin is a bit rusty.
Well, it means I don't give a I don't care. Look it up. And by the way, out of curiosity, by show of hands, how many of you went to fancy prep schools or schools with enlightened curricula and actually studied Latin in high school or college? Well, good. I'm going to ask those of you who put your hands up to help keep Keith honest today as he pretends to speak fluent Latin.
Well, Rick, look, if you don't care about Latin maxims, let me mention something that you should care about, and that's Delaware law. I've got a copy of then Vice Chancellor Strine's opinion in the Abry Partners case, and he makes it very clear that what you're proposing to do, which is to disclaim all liability for fraud with respect to the reps in the stock purchase agreement, it won't fly. You just can't do it. Jessica, you're the scholar here. Tell us what Abry Partners says.
What Abry Partners says is that it backs up your position, Keith. Rick's proposed disclaimer would be both invalid and unenforceable because if your client, the seller, is telling an outright deliberate lie when it makes the reps in the purchase agreement, your client will be liable without limit for the full amount of the damages that Keith's buy-side client suffers. No 10% cap, no limit of any kind. It's really a matter of public policy, as then Vice Chancellor Strine noted.
So Keith is right?
I'm sorry.
Okay, Keith, well, you got me. I take your point. I'll back off. Far from me to contradict the wisdom of Leo Strine, one of my favorite judges. But Judge Strine makes another point in that same decision that I do want to pursue. He points out that even though the buyer can't validly disclaim intentional fraud with respect to representations inside the acquisition agreement, a buyer can validly disclaim fraud relating to representations and other statements made outside the agreement, extra-contractual fraud as opposed to intra-contractual fraud. And that's what I want to do here. Disclaim, basically, your client's right to sue for extra contractual fraud.
Wait, you mean you want to disclaim liability for everything your client is telling my client in our due diligence discussions with the seller and in the management presentations he's leading? How would you disclaim that?
Well, you disclaim it with a simple boilerplate provision in the stock purchase agreement, Keith, called a non-reliance clause. Judge Strine, in his opinion, calls it an anti-reliance clause, but it is basically the same thing. So here's what it would look like. Very basic. The clause would say simply that except for the express written representations made by the seller in the stock purchase agreement, the buyer is not relying on any representations or other statements made by the seller. And let me turn to our scholar on the panel here. Jessica, do you agree that a non-reliance clause works and operates to eliminate liability for fraud outside the contract, such as fraud committed in oral due diligence discussions?
Well, this time, Rick, you're the one who's right. When I went through that definition of fraud earlier, I mentioned that reasonable reliance by the buyer is a necessary element the buyer would have to prove in their fraud claim. So reliance, think about it as like a leg of a stool. It's one of the legs that have to be there to support that fraud stool. If that claim can't stand, it's going to fall over. If you kick out that reliance leg of that stool, the whole thing falls over. So if no reliance, then no fraud. And in the Avery Partners' opinion, Judge Strine made clear that under Delaware law, a properly drafted non-reliance provision works to eliminate the buyer's liability for extra contractual fraud. So it does work in Delaware. It may or may not work under other states' laws, but this hypothetical stock purchase agreement and our hypothetical facts are governed by Delaware law.
That's great. So you guys have convinced me. It works. But why in the world do you think my client would ever agree to it? The fact is, my client, the buyer, is relying on everything your client says or otherwise provides in due diligence, whether it's mentioned in the acquisition agreement or not. The due diligence conversations are important. Why would I say the buyer is not relying on those statements when in fact it is?
Well, tell your client not to. No, seriously. And I don't mean this facetiously at all. Tell your client not to rely on anything outside the four corners of the stock purchase agreement. If there's any statement or piece of information that your client gets in due diligence that is central to your client's decision to do this deal at this price, in other words, if there's anything that your client hears or receives in due diligence that's not already in the contract that it is truly relying on, then enshrine it in an express rep in the stock purchase agreement, and you'll be covered. It'll be intra-contractual fraud.
Rick, that all sounds good, but you just spent so much time complaining ad nauseum about the length of your client's reps and warranties, and now you're suggesting we add more and take another week to negotiate those? But let's put that aside for a moment. Fundamentally, you're telling me that your client has a license to lie in due diligence. Your client could just make stuff up out of whole cloth and get away with it. That's not the way it works, Rick. But let's do this. Why don't you tell me right now what your client wants to lie about? I'll ask my client if that's okay, and if he says it is, we'll be done with it.
Keith, I warned you at the outset, you've got to be practical. Everyone knows there's a lot of loose talk in these free-flowing management presentations and other oral discussions outside the acquisition agreement. As I said, you can enshrine the oral statements that you consider really important in express written reps in the stock purchase agreement. And look at it from our point of view. If we don't get this non-reliance clause, and your client, for any reason, is disappointed after the closing with the business it bought, it's going to scour its due diligence files and its notes of its conversations with the seller and look for inaccuracies. And then, with the benefit of hindsight, when it finds a few inaccuracies, it will sue my client, the seller, for extra contractual fraud. Or even worse, it will claim that the seller made inaccurate oral statements that weren't even made, and then allege fraud. And it will do this even though every single rep in the stock purchase agreement was 100% accurate, and my client can't accept that reality.
Look, Rick, my client's reluctant to give up a right, the right to recover extra contractual fraud that it has today. Why should it do that? But I will concede that I have seen acquisition agreements that include this so-called non-reliance provision that you're requesting. So in the spirit of compromise, let me propose a compromise to resolve the issue. I'll give you a non-reliance clause if you give me a simple proviso to that clause. And the proviso is up on the screen. It basically says that notwithstanding the non-reliance clause or anything else in the agreement, the buyer retains all of its fraud remedies. I've heard that referred to as a fraud carve-out, and there's what it looks like. So we'll split the baby. That work?
So we're going to split the baby, huh? Let me read this. Keith, looking at this, I thought we were negotiating constructively and in good faith here. But of all the circular arguments you've made today, this one may be the most outrageous and disingenuous of them all. Your proposal isn't splitting anything. It's completely eviscerating the non-reliance clause and pushing the risk 100% to my client's side. What good is a non-reliance clause to me if you give it to me with one hand and then with this red language, take it away with the other hand, completely negate it? You must think I'm either an idiot or a complete pushover. Don't answer. But the answer is no. My answer is that I'm insisting on a non-reliance clause without a fraud carve-out. And okay, let's step out of character. And before hearing from Jessica on this issue, I'd like to do an informal audience poll by show of hands. Having heard this spirited debate, I would ask you which position you're most sympathetic with. It'll be either position number one or position number two. The buyer's position is number one, which is that the buyer should have the right to sue and recover from the seller for extracontractual fraud. The seller's position is position number two. The seller should get a non-reliance clause without a fraud carve-out, completely eliminating the buyer's right to sue and recover for extracontractual fraud.
So who thinks the seller shouldn't lie or the seller should lie?
Okay. Who is more sympathetic by show of hands with number one, the buyer's position? The buyer should have the right to sue and recover from the seller for extracontractual fraud. Let's talk about the real world. Jessica, in your experience, how do you see this fight coming out in the market? And then I'll ask Keith the same question.
We look at this exact issue in the ABA Private Target Deal Point study published by the M&A committee of the ABA's business law section. I co-chair that study with Tatiana Paterno of Bass Berry. In our most recently published iteration, we had a data set of 108 mid-market deals from 2022 and the first quarter of 23, and 74% of that data set had an express non-reliance provision. But 44% of that 74% contained a fraud carve-out to the express non-reliance provision. So when you net that out, the result is that in over half the deals surveyed, 58% of our data set, there was no effective non-reliance provision such that the buyer should still retain its right to recover for extra-contractual fraud in addition to the intra-contractual fraud. And you get a sneak preview today because we're working on the next iteration of the study. This is not out yet and has not been revealed anywhere else before today. But we're working on the new study. Our data set's 140 deals from last year and the first quarter of this year. And in that sneak preview data set, we see that deals with express non-reliance provisions have actually gone up. It's 81% of our study set. And only 26% of those 81% contain the fraud carve-out to the express non-reliance provision. So again, when you net it out, we're down to 40% of our data set with no effective non-reliance provision.
So it seems, based on your study and the soon-to-come iteration of your study, sellers are pushing back on this issue, and they are insisting on basically no liability for extra-contractual fraud.
I think presentations like this one are alerting folks to the fact that it doesn't make sense to have a fraud carve-out layered on top of a non-reliance provision. Either have the non-reliance provision or don't, but the fraud carve-out kind of takes away the purpose.
Oh. Gives with one hand and takes away with the other. Keith, your views out of character.
Yeah, I just think the whole thing's stupid. I mean, 10 years ago, we would never have this discussion. And it's these dumb studies that now we're having the discussion. It just doesn't make sense to me. And I'd say I represent mostly large cap, mega cap buyers. And they very often win this point. They don't agree to these non-reliance provisions, or if they do, they get the carve-out that Rick was complaining about. It just doesn't make sense to them or to me, honestly, to allow somebody to commit fraud, whether it's inside the contract or outside the contract, and get away with it.
At the end of the day, this has to be negotiated as a business issue. But Jessica, let's assume that I, representing the seller, win this point, and I succeed in getting Keith to agree to let me disclaim liability for extra-contractual fraud. What drafting advice do you have for me and for others in the audience in drafting my disclaimer to include in the acquisition agreement? What should I know as a legal matter?
The first thing you want to do is you want to make sure that you're drafting a clear and unambiguous non-reliance provision that actually contains some variation of the term rely. And I know there's plenty of fellow deal wonk nerds out here in the audience going, but wait, Prairie Capital and IAC have indicated to us that no magic words are actually required to disclaim reliance. You can instead get to an anti-reliance provision by looking at a combination of multiple provisions in the underlying purchase agreement. And I think we've got those cases within our slides. But I think most M&A practitioners who follow these issues would maintain that it's still your best bet, Rick, to use an express and focused non-reliance clause that does include some formulation of the word rely in it, just in order to avoid any confusion about the intent or the agreement of the parties on this point.
Good advice.
I have a little more good advice. You're going to want to make sure your non-reliance clause is actually located in the right part of your purchase agreement. Too often, you'll see someone put the non-reliance clause as a rep or acknowledgement by the seller. It needs to be a representation or acknowledgement by the buyer. When you say it out loud, you can see why it doesn't work, right? You can't have the seller representing to the buyer what the buyer did or did not rely upon, and yet people put it in the wrong place regularly. If you take a look at the FDG case listed on this slide here, it cautions that a functional disclaimer of reliance, quote, must come from the point of view of the aggrieved party. So make sure you put it in the right place, Rick.
All great advice for the folks in the trenches that are tasked with drafting these provisions that have to be drafted properly. But now Keith and I are going to step back into character and continue our negotiation on this point, and spoiler alert, I may not win it after all. So, Keith, you mentioned at the outset that you, the buyer's counsel, were asking for three things, three fraud-related provisions in the acquisition agreement. The first one was a provision preserving your client's right to sue for fraud, including extra-contractual fraud, fraud outside the contract. So in effect, you're saying you won't agree to a non-reliance clause, and instead you want specific verbiage that expressly underscores the fact that your client will have the right to recover for extra-contractual fraud, for fraud in due diligence discussions, for example, right?
That's right. That's exactly what I want. I won't give your client a license to lie. Big strategics like my client win this point all the time. And so, yes, that's what I want.
Okay. In the interest of making progress, I'm going to fall on my sword on this one. You win. I and my client, the seller, gracefully agree that there will be no non-reliance clause, so your client can sue my client for both intercontractual and also for extra-contractual fraud, fraud committed by my client outside the acquisition agreement as part of due diligence discussions. So I'm giving you the first of the three things you asked for at the outset of our negotiation. I'm handing it to you on a silver platter. Let's turn now to the second thing that you asked for. You said you wanted a standard definition of fraud. What do you mean by that? Jessica has already gone through the legal elements of fraud. You want a contractual definition, a standard contractual definition of fraud. What's a standard contractual definition?
Super simple. So the definition I'm insisting on is that fraud means fraud as defined in the Delaware common law. The words are on the screen, but admittedly, it's somewhat circular, but because it refers back to Delaware law, I thought it would be completely non-controversial for you, Rick. The definition simply provides my client with what it already has: the right to sue your client, the seller, in tort under Delaware common law. The same rights it has today, the right to sue for both intercontractual and extra-contractual fraud in tort. You've already conceded there will be no non-reliance clause, so I assume you're totally fine and possibly even enamored with this basic definition, and we can move on.
Enamored. Look, not so fast, Keith. I'm not okay. I have a problem, actually multiple problems with your so-called definition of fraud. First of all, Delaware common law, to which your definition ties, has a bunch of built-in traps. For example, Delaware common law recognizes certain types of fraud that don't require scienter at all. Equitable fraud is an example. I can't expose my client to fraud-type liability for misrepresentations it may make that are innocent or merely negligent for that matter, rather than intentional. Our contractual definition of fraud needs to require some sort of scienter.
Well, Rick, equitable fraud is a very technical concept, as you know. In most cases, there has to be some sort of special relationship between the parties before the buyer can sue a seller for equitable fraud. But still, I take your point. And I'd be willing to include in my definition of fraud a specific requirement of scienter. With scienter defined the way Jessica laid it out in her legal definition of fraud: specific intent to defraud or recklessness, reckless disregard for the truth. You happy now?
No, still not happy. You had me at specific intent, but I'm uncomfortable with what you added, the or prong of your request. I'm uncomfortable with a definition of scienter that includes anything beyond specific illicit intent to commit fraud. I can't allow your client to recover anything unless it can show that my client had actual knowledge that the rep or statement made by my client was wrong, and my client made the statement anyway. Recklessness, which is a component of the definition that you're asking for, is a very slippery concept and one that I can't align with here. If you put the reckless prong in the definition, what sort of due diligence does my client, the seller, have to do before making a statement to your client in order to ensure that he won't be deemed to be acting recklessly?
Rick, come on, talk about being practical. Are you saying that in the case of a written contractual representation, intra-contractual fraud, that if your client, the seller, doesn't know for sure that the rep he made in the SPA is false, but is clearly reckless in making the rep, he won't be liable for fraud?
Yeah,
even though my client has the right under Delaware law to get
that is
recovery?
Exactly what I'm saying, Keith. If there is no illicit intent, and recklessness is not illicit intent on the part of my client, if there's no deliberate fraud with actual knowledge by my client that the rep he made in the stock purchase agreement was false, then your client cannot recover for fraud.
Rick, I hate to go over old ground, but that would be an invalid definition of fraud. We covered this already. You're trying to waive liability for clear intra-contractual fraud within the four corners of the contract. And back when we asked for a disclaimer in that context, we determined, and you conceded, that you can't legally do that. I have to say, it's really frustrating for me to sit here and have to repeat myself. I sound like I'm talking to my 11-year-old daughter. I just think you're not listening. And I'm getting a little sick and tired of your intransigence.
Look, Keith, I'm not quite sure how to respond to that personal attack, so I'm going to have to revert to my now favorite Latin saying, flocci non facio. Remember what that means? And if you don't, there are some folks in the audience who can help. It means I don't care what you think because your point is dead wrong. And let me remind you, with Jessica's help, of exactly what Judge Strine said and did not say in his Avery Partners decision. Jessica, Judge Strine did not say that all types of intra-contractual fraud are non-waivable. Tell him.
Yeah, what Judge Strine said in Avery Partners is this, and we've got his words up on the screen. Quote, to the extent that the SPA purports to limit the seller's exposure for its own conscious participation in the communication of lies to the buyer, it is invalid under the public policy of this state, unquote. Note the words conscious participation in the communication of lies. Merely reckless statements are not lies. Strine's words preclude the seller from exculpating itself from deliberate, conscious, intentional, intercontractual fraud where the seller has, in Judge Strine's words, an illicit state of mind. And then Judge Strine goes on to say specifically, and again, the words are on the screen, likewise, the buyer, Keith's client in our hypothetical, may not escape the contractual limitations on liability by attempting to show if the seller acted in a reckless manner. So in other words, with the right language, the purchase agreement can indeed let seller off the hook for seller's own recklessness in the making of its reps in the purchase agreement. So Keith, you asserted that the seller cannot be exculpated from its own recklessness, but that's incorrect. So another point for Rick, if you're keeping score. A definition of fraud like that being proposed by Rick, which excludes reckless behavior by the seller and is limited only to those deliberate, intentional conduct type of situations in making those false intracontractual reps, is a valid definition of fraud.
So, Keith, I'm going to refrain from asking you for the apology that you so clearly owe me for your blatant mischaracterization of Judge Strine's opinion. Instead, I'm just going to ask you to graciously and humbly fall on your sword and concede the point. In other words, the point that we will agree to a contractual definition of fraud that will include only deliberate behavior on the part of the seller, with actual knowledge of the falsity of the reps the seller made in the SPA, and will specifically say reckless behavior won't cut it. Reckless behavior does not constitute fraud for purposes of this definition. That's how we'll agree to define fraud in scienter for purposes of the acquisition agreement. Do you agree?
Well, I didn't know you were going to bring Jessica with you, but yeah, you got me this time. I will fall on my sword and I'll agree to accept your definition. Mere reckless behavior won't cut it. Since you let me get away with including a non-reliance clause, I'll let you win this one.
So I told you I'd make you pay for eliminating the non-reliance clause. And Jessica, let's get back to real life. Let's step out of character. In your experience, how frequently do the parties raise and fight about this issue regarding the appropriate definition of fraud? And does the buyer frequently lose the point, as Keith has lost it here, and agree to exclude seller conduct that is merely reckless from the definition of fraud? In other words, is the trade-off that Keith and I worked out here, is that a common trade-off in real life?
Yeah, and you asked also how often it comes up. It's a starting point that not all sellers' counsel raise this issue to begin with.
And why is that? Not everybody appreciates the important nuances that we're here to talk about.
That's right. And when a seller does bring it up, when they do ask the buyer to exclude seller conduct that is merely reckless from the fraud definition, in my experience, it's pretty difficult for the buyer to argue against that. And that stems back to the simple reason that sellers are asked to make many representations within the purchase agreement that they either don't know to be true or cannot know to be true as a matter of risk allocation in that particular function of the representations, because that's how the parties are allocating the risk of an unknown problem that could pop up post-closing.
Yeah, so Keith, out of character, same question, but maybe through the lens of large cap strategic buyers that you and I typically represent in real life. Are you sometimes agreeing to this trade-off and getting rid of the non-reliance clause and agreeing to exclude merely reckless conduct from the fraud?
I am, for the reasons that have already been stated, but let me give you an example why. So every buyer in a tech acquisition, which I do a lot of, asks the seller to represent that the target company's intellectual property doesn't infringe any third-party intellectual property. The buyer's going to insist on getting the rep anyway because that's how it protects itself against unknown infringement, even though the seller hasn't often looked to see whether there's infringement. And so if it turns out that there has been, the buyer can still seek indemnification from the seller for breach of the IP infringement rep, subject to whatever caps and other things we've negotiated. So I don't think it's difficult for a buyer to insist on broad risk allocation reps on the one hand, and then argue. I do think it's tough to say, I want broad risk allocation, and then argue, but I want to exclude all of the caps and limitations if there's recklessness. Right. So I do think it's a fair trade.
I'm going to count that as a point for me.
Okay, you don't get points. Okay, back to our negotiation. Let's turn to our third and final fraud-related provision you requested at the outset of our negotiation. You said you wanted a standard fraud indemnity. That sounds a bit like an oxymoron to me. Standard fraud indemnity. I'd like to understand what you mean by that, because we've already negotiated an indemnity that I've been referring to as a general indemnification provision. And as part of the negotiation that we had, we've negotiated a dollar cap on my client's indemnification liability equal to 10% of the purchase price. So are we talking about the same thing here, the general indemnification provision?
We're not. We're talking about something different. The general indemnification provision you mentioned has your client, the seller, indemnifying my client for any damages or losses my client incurs as a result of an inaccuracy or breach of any of the seller's reps, whether those are intentional breaches, reckless breaches, negligent breaches, or even completely innocent breaches. That general indemnification is subject to the 10% negotiated cap, as you mentioned.
Yeah, and as we've said, we've already negotiated and locked down that provision. So are you asking for something else with this, quote, special fraud indemnity?
I definitely am asking for something else. I'm asking for an additional indemnity, a fraud indemnity on top of the general indemnity. The fraud indemnity I'm asking for is different. It's a lot narrower than the general indemnity. It only relates to fraud, as we've agreed to define the term. So it doesn't apply to reckless conduct. It doesn't apply to negligent or innocent misreps, just intentional ones.
So you're telling me that this special fraud indemnity that you're proposing is narrower than the general indemnity. It's just a little incremental addition to potential liability here, so why shouldn't I agree with it?
That's right.
But I still need to understand a little better, what would this fraud indemnity say?
So it would look something like the provision on the screen. It would basically say that in addition to the general indemnity that we've already discussed, your client will indemnify my client, the buyer, for any losses or damages that the buyer suffers as a result of any capital F fraud committed by the seller, by the target company, or by any of its associates. So very simple. It's just another sentence that goes into the indemnity section.
And you're telling me it's narrower than the general indemnity?
That's right. It only applies to fraud. It does not apply, as I said, to non-fraudulent misreps like the general indemnity does. And it only applies to intentional fraud, not even reckless fraud.
So I should agree to it, of course. But let me ask you a few questions about the scope of this supposedly narrower fraud indemnity. Is the potential fraud indemnity and the potential fraud liability that can arise under that special fraud indemnity capped at 10%, just like the general indemnity?
No, it's not.
So it's not. Okay. Let me ask you another question. The general indemnity only applies to inaccuracies in the express reps contained in the SPA, right? So is the fraud indemnity similarly limited to reps inside the agreement?
Definitely not. We talked about that. So it applies to reps inside the agreement, and it also applies to extra contractual fraud, which we talked about.
So in other words, it also applies to anything said in oral due diligence presentation.
Well, it applies to lies that were made during the due diligence presentation.
And you say it covers fraud committed by, and it's in red on the provision here, committed by associates of the target company. Would it apply, say, to lies allegedly told by my client's investment banker on the deal?
Sure. Yeah, it would cover.
Because my investment banker is defined as an associate in this incredibly broad definition. So, Keith, let me get this straight. Your proposed fraud indemnity is uncapped. It applies to statements made outside as well as inside the acquisition agreement. And it covers fraud committed by everybody under the sun. And you're telling me it's narrower than the general indemnity, which is capped, which by its terms is limited only to reps inside the contract, and which is limited to reps made by the seller itself and not everyone under the sun? Doesn't sound like it's really that narrow to me.
Rick, it is narrow. Remember, it only applies to things your client intentionally lies about. So I guess if your client plans to lie a lot, it might not be that narrow. But if it doesn't plan to lie at all, or at least much, then it is quite narrow.
Spoken like a true lawyer. Would you agree that your client's rights to recover for fraud are more expansive with this special fraud indemnity than without it?
Of course I would. That's exactly why I'm asking for it.
Yeah. And I find it a little bit ironic that you've been saying
those liars out there
that you're only asking for what Delaware common law already provides. But here, you're asking to expand your client's rights significantly beyond what it has under the common law.
Rick, why do you have such a problem with my fraud indemnity? What specifically don't you like about it?
Everything. For one thing, just to give you one example, your fraud indemnity covers not only the seller's conduct, but also that of anyone even remotely connected with the seller. The way I see it, if people other than the seller defraud your client, and you can make out a good case that they committed fraud, then go after them directly, sue them in tort for fraud. But don't look to my deep pocket client as some sort of guarantor in this regard, which is what the language of your fraud indemnity essentially does.
But Rick, If the company's CFO blatantly lies to us in his management presentation, intending to deceive us, and we rely on his deliberately false statements, and as we're permitted to do so, since there's no non-reliance clause, why shouldn't we be made whole by the seller?
You should not. If the seller had no idea that the CFO's statements were false, then the seller shouldn't be liable for that. Sue the CFO personally in that case. He's the one who knew the rep was a lie. You have a clear case for fraud in tort against that CFO.
Yeah,
that's your remedy.
That's a practical solution. He doesn't have any money to make us whole. And his D&O insurance excludes a recovery for fraud. But more fundamentally, Rick, your client, the seller, should not be unjustly enriched by receiving a full purchase price for a flawed and frauded company.
Look, all I can say is don't make me speak Latin again. I can come up with a dozen hypotheticals to demonstrate why your fraud indemnity is inappropriate. And I think this unjust enrichment argument proves too much. You could argue that even completely innocent misrepresentations unjustly enrich the seller and therefore shouldn't be subject to a 10% cap. But no one's saying that my client should be liable beyond the cap for those.
We can revisit that if you want.
That's just circular words you're using. Let's step out of character here. And Jessica, let's tap into your experience. Are buyers generally requesting fraud indemnities? And are they successful in getting a fraud indemnity, even in deals without a non-reliance clause? And I'm raising this question because fraud indemnities are one of the things that not all lawyers practicing in this area are conversant with or even know to raise or know how to rebut. But what's happening on the ground here?
I do think that standalone indemnification for fraud is becoming a more common ask by buyers. I'd say it's prevalent. But I also see that when it is asked for, the sellers push back on the scope in order to use the same definition of fraud with a capital F used elsewhere in the purchase agreement, just as you've done.
Yeah, so Keith, out of character, same question. Based on your negotiating experience, mostly with large cap strategic buyers, are buyers successful generally in getting a fraud indemnity, even in deals without a non-reliance clause?
Yeah, I would say there's no question that the combination of a fraud indemnity with a definition of fraud that permits recovery for extra contractual fraud is a lot for a seller to swallow. But I'd also say that most of our buy-side clients are, in fact, getting them. The unjust enrichment argument often does carry the day, and sellers then try to put different limitations on that, but we're getting in the first instance and we're negotiating the limitations, not whether we have it or not.
Right. Fraud indemnity, a very, very important provision that is too often overlooked in these negotiations in our experience. So our time constraints and the upcoming reception require that we end things here and conclude our presentation on negotiating fraud-related provisions in business acquisitions. We hope it's been informative, but I do want to give our panelists a few minutes to reflect on the discussions we've had. Jessica, what is the most important thing that our audience should take away from our discussions today?
Well, study Latin. No.
Yeah.
I should have prepared something in Latin, but instead we'll go with Shakespeare and say fraud is a many-splendored thing. But seriously, the concept of fraud is more complex than it may seem, more serious and prevalent of an issue than you might have thought. And if you want to navigate this thorny area successfully in your M&A purchase agreements, you need to be up on the case law, you need to know the law, or you need to hire counsel that knows the law.
Right. Keith, any sort of overarching reflections or things that you think are the most important takeaways from what we've discussed today?
I will say that it definitely comes up in every deal, whereas, again, 10 years ago, it didn't come up at all. I've seen deals crater. Literally, people walk away from the deals as a result of whether or not there was a non-reliance clause in the agreement. I feel very strongly, again, I represent mostly buyers, but it just makes sense to me that the buyer should be able to recover if it can prove that it was intentionally lied to, whether that's inside the contract or outside the contract. We all know that so much of the due diligence we rely on is part of the deal. We're not gonna have a rep on all of it, but we have a lot of conversations with the client about customer lists. And let's just say we're not gonna have a rep on the customer list, but we wanna know, do you have a robust customer list? Are there any problems with customers? If that's wrong because the seller didn't know, it was an innocent mistake, that they just didn't know that a big customer had a problem, fine. But if they did know, or if they made up the customer list and they lied, and there's not a rep on that, why shouldn't a buyer recover without those caps? So that's, I guess, what I would say.
Okay, and my high-level concluding observations, regardless of what side you're on, this is a topic that can stir up emotions. Clients get really uneasy when they hear the word fraud, and understandably so. And often they'd rather not talk about the subject than go through the awkward process of negotiating about it because it carries certain presumptions that the other side, who you're trying to enter into a trusting relationship with, may commit fraud. But these provisions have to get negotiated, and negotiating them requires a delicate balancing act to be performed, as Jessica said, by experienced deal negotiators who really understand them. The lawyers need to be familiar with the applicable case law, and they need to have the deal experience to come up with creative solutions to thorny liability issues. Drafting and negotiating these provisions is most definitely not a fill-in-the-blanks exercise where you can just copy the provisions from your last deal, although I see that happening all too frequently. And remember, in real life, allegations of fraud are sufficiently common that you are making a mistake if you just skate over these hugely important provisions, particularly in big-ticket transactions. So if you have any questions, we'll answer them at the reception. Anyone who wants access to the animated cartoons we've done on this and other topics, please either leave me your business card or shoot me an email or buttonhole me at the reception, and we'll provide them to you, including our latest cartoon titled appropriately Fraud Face Off. Thank you all for your attention. Thanks for coming.